वेलकम टू कानून गुरुज। आज हमारे साथ हैं एडवोकेट मेघान पॉल, जो कि दिल्ली हाई कोर्ट में प्रैक्टिस करते हैं।
Thank you for inviting me.
थैंक यू सो मच फॉर योर टाइम। ओके सर, बिफोर वी स्टार्ट टॉपिक, हम लोग जो है आपकी लिटिगेशन जर्नी के बारे में जानना चाहेंगे, यानी हमारे जो व्यूअर्स हैं वो आपका लिटिगेशन जर्नी है उसके बारे में जानना चाहेंगे।
So I did my graduation from Campus Law Center, a 3-year law course, and thereafter I worked with CBI and ED, the prosecution agencies, for a couple of months, for around 5 to 6 months, and then I went independent quite early in my career. But I got a few good cases at hand. In the beginning of my career, I did a CBI matter, a corruption case, and thereafter a couple of good cases, wherein one of which is the WhatsApp's privacy policy case. And Mr. Sybil tends to appear for respondent number 2 in that case, which is WhatsApp. So those a couple of the other cases as well. So just the journey, and the journey has been well enough till now, with God's grace.
So it's very difficult to deal with the CBI cases.
I would say that the CBI is a more more experienced prosecution agency. It will leave you with less lacunas than with the normal police agencies, with the normal special cell or the crime branch agencies. The CBI is a better prosecution agency, I would say.
तो सर, आज का हमारा जो टॉपिक है वो है फॉल्स प्रॉमिसेस ऑफ मैरिज, और काफी लिटिगेशन जो है इंक्रीज हो रहे हैं इसी पर्टिकुलर टॉपिक पे या इसी कंसर्न पे। तो क्या है ये फॉल्स प्रॉमिसेस ऑफ मैरिज, क्यों इतना ज्यादा हाईलाइट हो रहा है इन दिनों?
These days, the false promise of marriage is basically the trending topic. Gone are those days where we have seen forceful rapes taking place. There are brutal rapes, Nirbhaya cases, and others. Gone are those days. Now the days have changed. Now the litigation has gone towards a false promise of marriage. And interestingly, in this case, a consent is there. A consent is there. Undoubtedly, we have read under the clauses of rape that there is without her consent, the clause without her consent. Now, where do we get these provisions? Let us first get into the nitty-gritties of the provision. कि provision क्या कहता है, IPC क्या कहता है in जो false promise
In a
of
point
marriage
of
हो गया.
false promises of marriage.
Yeah, surely. False promise of marriage कहाँ से आता है, प्लस रेप क्या कहता है, सेक्शन 375 क्या कहता है. So I'll just read in context to the false promise of marriage only 2 sections, not complete reading of those 2 sections, but only to the subject of a false promise of marriage. 375 talks about rape, and it says a man is set to commit rape if he provides with a couple of circumstances, and one of those circumstances is without her consent, which is the second circumstance. And therefore, it becomes pivotal to understand context in the larger perspective, in a broader perspective. Where does the consent lie? How is the consent given? How is the consent said to be vitiated under law? Now, all of these will give you an answer whether in a particular fact of a case, whether a false promise of marriage is made out or not. So to understand consent, we have to go to explanation number 2 of section 375. Now, what does consent actually mean? Or what did the IPC framers said something as consent? Consent means an unequivocal voluntary agreement when the women, by words, gestures, or any form of verbal or non-verbal communication, communicates willingness. Now, this means willingness is to be communicated, and that can be communicated through non-verbal means as well. That means through acts, other than stating that I'm giving you consent. There are other means of conferring consent. There are other means of communicating consent to the other person. Now, consent undoubtedly has not been defined under the IPC. What is defined under the IPC is what is not consent. What is consent is a topic which the IPC framers never took up. So they define what is not consent. In section 90, and in context of the false promise of marriage, section 90 becomes very important to be read. So section 90, just give me a minute. I'll read section 90 and I'll explain to each and every one of you what exactly section 90 states. Consent known to be given under fear or misconception. Now, fear is not a case for this debate or discussion, but a misconception. A consent which is based on misconception of a fact is no consent. And this false promise of marriage has to be now understood in this realm, within this ambit of a misconception of fact, a fact which vitiates consent. Consent has already been given, but that consent is no consent under law. That is where this discussion will be led. So therefore, where a woman does not consent to the sexual acts described under section 375, the offense of rape has occurred. That's the dictum of section 375. Where consent is missing, rape is going to be there. The offense of rape will be made out. But where a consent is there, will the offense of rape still be made out or not? That's another question. Now, if a consent is there and the girl makes an allegation, goes to the police officer, gives a complaint that, well, this consent was obtained due to a false promise of marriage or due to some other misconception of fact, the police officer will register an FIR, get the accused arrested. In most of the cases, they are arrested. And thereafter, the prosecution agency will begin the investigation, will get the complaints, will get the 161, will get the 164 of the prosecutrix, and thereafter will file the charge. And you get bails and all other forms, whatever you want from the court. Now, what we have to understand now is what exactly is consent. What is consent under law? Consent has not been provided. Section 90 does not talk about consent at all. It says what is not consent. But then again, we will have to prove that there was consent to the court. How do we do that? And in context of this, I will refer to a few judgments of the Honorable Supreme Court, one of which is my most used judgments, and I've got bails referring this judgment to the courts. This is the Pramod Suryabhan judgment of the Honorable Supreme Court. A 2019 judgment of the Honorable Supreme Court and authored by Justice Chandrachud. A quashing petition. It's a false promise of marriage case. A quashing petition went to the Supreme Court, and the Supreme Court
So
indeed
sorry to
quashed it.
interrupt you. It was your personal case, like you
No,
appeared in personally.
no. This is a landmark judgment. I did
Okay,
not appear in this case, but I've
okay.
used this, I've referred this case in my personal matters before the Honorable Trial Courts and the Honorable Delhi High Court. So, what exactly has been defined to be a consent under law? And I'll quote from para 12 of the judgment. So consent with respect to section 375 of the IPC involves an active understanding of the circumstances, actions, and consequences of the proposed act. That means it's a well reasoned judgment. A consent means the other person is able to understand the consequences of the act, able to give a well reasoned judgment, and is able to understand all the actions that are going to take place or are taking place. Further, an individual who makes a reasoned choice to act after evaluating various alternative actions as well as the various possible consequences flowing from such action or inaction consents to such action. That means consent is basically a deliberation. That means mind has been used completely. It's no case of non-application of mind. Consent means an application of mind is there. The person has understood in which circumstance he is or she is in. मतलब वहां पे सिंपल लैंग्वेज में बोलूं, वहां पे इंसान समझता है कि किस एक्ट में वो है अभी, क्या उसके कॉन्सिक्वेंसेस होंगे और क्या उसके कंसेंट का महत्व है. सिंपल लैंग्वेज. Thereafter, consent has been further defined. How do you infer consent? In one of the judgments of the Honorable Supreme Court in Dhruvaram, Sonar, how the Honorable Supreme Court defined as to where do we infer consent from. The prosecutrix is never going to say that I gave my consent freely. It may have been for free. It may not have been for a promise of marriage. There may have been some vendetta against the accused person. Could have been. But where are we going to infer consent? कंसेंट कैसे हमें पता लगेगा एक केस में कि कंसेंट दिया गया है कि. तो सुप्रीम कोर्ट ऐसे डिफाइन करता है. An inference as to consent can be drawn if only based on evidence or probabilities of the case, not just through the testimony of the prosecutrix, but the probabilities of the case may be many. The place of incident, there could be a delay, there could be other witnesses testifying the fact that there was a possibility of consent, there could be a relationship. So all of these circumstances, the probability is the one which is going to define whether a consent was there or on the basis of an evidence. A positive evidence may define that consent was there and that was free, that was not vitiated by a misconception of fact. Therefore, consent plays a vital role because with consent, the
So in a
offense of
point
sex.
of what is the role of consent?
That's what I'm coming to. The role of consent is, and that's a very, very vital role. The role of consent is it negates the complete offense of section 375. You're out of 375 the moment you prove consent. You cannot be prosecuted. You cannot be tried by court law. If you prove consent, you're free. As I would say, you're free if you can prove consent. And the way to prove consent would be maybe through evidences, maybe through proving probabilities that there was consent, and so on and so forth. Now, it becomes very important in context of consent to also understand what is a misconception of fact, what is a false promise of marriage, and what is a breach of that promise of marriage. Now, it is a very interesting fact that many of the viewers may not be knowing that in foreign lands, in European countries, in American countries, there is no rape on the pretext of marriage. There's only a breach of marriage. It is only due to the Indian values that we have developed this. Now, I'm not saying that it's a good thing or a bad thing, but That is in the context of the Indian values that we've developed.
What type of values?
You can say a conservative value, that we are too grounded, we've been ancient, we know how to respect women, we know that making false promises is not a good thing. Maybe also the IPC defining consent and a misconception of fact, all of that. So now, misconception of fact, there is a very important distinction to be given. And I'll again quote the same judgment, Prabodh Suryabhan, para 14, which defines the complete misconception of fact. Specifically, in the context of a promise to marry, this court has observed that there is a distinction between a false promise given on the understanding by the maker that it will be broken, a false promise given, and the maker knows that it will be broken. There's a difference in this and the breach of promise to marry. A breach of promise may be due to some other condition. Let's say, let's take up for an example that the accused and the prosecutrix belong to a different caste. When the accused made a promise to marry and an act ensued upon that, he he may probably think that the marriage may be successful, may be solemnized and may be successful. But subsequently, due to certain conditions, the marriage was never successful. Let's say the interference of the parents. Due to the interference of the parents or the society, the marriage was never made successful. So in those cases, a misconception of fact is not. Because when the maker of that promise made that promise, he believed that the promise is true. Therefore comes a vital role of intention. When the person is making a particular promise, what is the intent of that maker? Whether the intent of the maker is to deceive the prosecutrix for a particular act, or whether the intent is truthful and later on, due to other circumstances, the promise never gets ensued, the promise is never fulfilled. So therefore, this also becomes very important to understand when it comes to promise of marriage, that whether that promise was false from the very inception itself, जब वो प्रॉमिस करा गया था, क्या तब से ही वो प्रॉमिस नहीं निभाने वाला था, या फिर बाद में चल के कुछ ऐसे सर्कमस्टांसेस आ गए जिससे वो प्रॉमिस फुलफिल नहीं हो सका. In that case, in the case of this false promise of marriage from the inception and a breach of that promise, it's only the false promise from the inception itself that is punishable under law. It is never the breach of that promise which is punishable. So breach of the promise will save you from section 375 if it is due to some other circumstances which may have come up subsequently, although that promise was made under goodwill with the intention to fulfill that promise. But thereafter, certain
So
circumstances
what
came up.
is the sorry to interrupt you. What is the meaning of intention in false of promises of marriage?
Intention, very well. So, intention means, see, intention is a reasoned decision again, that I know what I am doing. The person, the maker of that promise, knows what he is doing. The intention of the maker of that promise, if the intention is to deceive and lure that person to perform a sexual act, and that person making that promise knows it very well that the consent would not be given, without such a promise, and this promise is never going to be fulfilled, in that case, the intention of the maker is false. The intent is never to get that promise fulfilled. Whereas, in a case where subsequently some developments have taken place and that promise to marry due to some subsequent developments can never be fulfilled, in that case and only in that case it's a breach of promise, and the intention then at the outset becomes true. So therefore I'll refer to one more judgment, Deepak Gulati versus State of Haryana, again of the Honorable Supreme Court in 2013. Now, these four judgments are very important. The one which I'm referring to is the Pramod Suryabhan judgment. Now, these judgments are landmark laws on this rape on the pretext of marriage. This will save any person. If they know what the law is, they may save their clients. They may, anybody may be in safe hands. So, what the Deepak Gulati judgment states is there's a distinction between the mere breach of a promise and not fulfilling a false promise. As I just said, there's a distinction. A breach of promise is something else. Non-fulfillment of a false promise is something else. Thus, the court must examine whether there was made at an early stage a false promise of marriage by the accused. Now, this examination is the examination of intent. Whether the maker of that false promise intended to make a false promise just to lure and deceive the prosecutrix, or whether the maker had an intent that the promise is true and I will fulfill my duties or whatever the promise is made of. Now, thereafter, having understood the misconception of fact, it is very important to put all of this now together for all the viewers, of course. Therefore, where the promise to marry is false and the intention of the maker at the time of making the promise itself was not to abide by that promise, but to only deceive and lure the prosecutrix for engagement in a sexual relation, in that case, there is a misconception of it. Consent then becomes vitiated under law. But in case of a breach of promise due to an interference of some subsequent event, it will not be. That is not a false promise. The consent is valid under law. Therefore, what till now what we have understood is that consent plays a vital role when it comes to section 375. Consent can save you from the whole offense. Consent now is not defined under law. Therefore, to understand consent, we have to understand what is not a consent. And therefore, we went to section 90, which talks about what is not consent and when is a consent said to be vitiated under law. And that is when it is vitiated, when there is a misconception of fact, when the prosecutrix is being lured into a particular act on the basis of a falsity. Therefore, now Deepak Gulati is a very important judgment because there is one more observation in Deepak Gulati, which is very interesting and which I have used a couple of times, and there may be many who can use it again. So Deepak Gulati in para 21 states there may be a case where the prosecutrix agrees to have sexual intercourse on account of her love and passion for the accused, and not solely on account of the misconception of fact given by the accused. Now, in that case, when the consent of the prosecutrix is given due to the love and passion and not due to the misconception of fact, in that case, the consent is there. because the consent is not lured by the misconception of fact. In that case, her consent, the consent of the prosecutrix, would be there on the basis of the love and passion she has for the accused. And therefore, this will also be a consent under. Even though there's a misconception of fact, there may be a false promise. But if you can prove this, that the consent was obtained on the basis of love and passion, in that case also, the consent will prevail, and that will not be covered under the misconception. Therefore, in order to come within the meaning of the term misconception of fact, the fact must have an immediate relevance. It's not like a promise was made 2 years back and the consent was given after 2 years. It must be immediate. It must have a direct bearing. That misconception of fact must have a direct bearing on the act. It cannot be a very slight misconception. Well, because this person promised me to take me to a particular place and therefore I gave my consent. That cannot be true. That must be something which may have a direct bearing, something so immediate that the relevance that it may play in such an act is great. And lastly, I'll just read what the conditions are required for a rape on the pretext of marriage. Well, this goes for the prosecution and the defense both, and thereafter we can take up some questions by you. So firstly, there are two conditions. Now these two conditions are very important, which needs to be proved by the prosecution and be disproved by the accused person. So firstly, it must be shown that the consent was given under a misconception of fact. That's the first condition. But that solely alone cannot get a conviction in the case. A misconception of fact solely alone cannot be made a ground for conviction. There is another condition which is required. The second condition is the person who obtained the consent knew or had reason to believe that the consent was given in consequence of such misconception. Now, there kicks in the love and passion. You can have, in some cases, there may be love and passion due to which the prosecutrix gives her consent to the accused person. But in those cases, the misconception of fact, even if it is there, will not be calculated or counted. The consent has been obtained due to the love and passion in that case. Now, therefore, the promise of marriage, now I'll just sum it up. Therefore, the promise of marriage must have been a false promise given in bad faith and with no intention of being adhered to at any time in the near future. Therefore, the false promise itself must be of immediate relevance or bear a direct nexus to the women's decision to engage in the sexual act. मतलब कि जो false promise of marriage है, पहली बात तो प्रोसिक्यूशन ये प्रूव करेगा कि जी जो प्रॉमिस किया गया है, ठीक है, वो जो प्रॉमिस मेकर है उसका इंटेंशन नहीं है कि वो प्रॉमिस को फुलफिल करे. दूसरी बात वो प्रूव करेगा कि जो वो प्रॉमिस किया जा रहा है, ठीक है, अक्यूज्ड या जो भी एक्यूजेशन जिनके अगेंस्ट भी लेवल की जा रही, उसको पता है कि वो जो कंसेंट है सिर्फ और सिर्फ उसी बेसिस पे दिया, ना कि लव एंड पैशन के बेसिस पे दिया जा रहा है, ना ही किसी और बेसिस. I'll just refer to one more very interesting observation by the Honorable Delhi High Court. Now, the judgment of Pramod Suryabhan I've already discussed in detail, in depth. But there is one observation of Justice Subramaniam Prasad sitting singly in the Honorable Delhi High Court. Now, this is a quashment petition before the Honorable Delhi High Court on the basis of compromise. This is again under Section 376. And the very interesting observation in para 15 of the said judgment is allegations regarding offences such as one under section 376 IPC cannot be made at the drop of a hat in order to settle personal scores. That means just for a vindication or revenge, or a vendetta or revenge, you just cannot level these allegations. And in fact, when it comes to promise of marriage, the allegations are made more easier than this one, because it is easy to define delay then in that case, easy to state a couple of other things as well. Therefore, the Honorable Delhi High Court was pained to see as to how the alarming cases under Section 354 A, B, C, D, and 376 are coming up these days. And I think by this I have completed the rape on pretext of marriage. Thank you.
तो सर आप कानून गुरु से रिसेंटली जुड़े हैं, आपकी नज़र में किस तरीके का प्लेटफ़ॉर्म है कानून गुरुज़ और किस तरीके के व्यूज़ हैं आपके कानून गुरुज़ को लेके?
See, I have been following Kanoon Guru for a while now. This helps me a lot. And in fact, I've watched a lot of your videos that have helped me, and I believe it would have surely helped my fellow young advocates and law students as well. And I'm thankful to such platforms and thankful to you for having worked so hard for all of us. And thank you for providing us such a wonderful platform, which is a one step for every legal solution, I believe. Thank you.
We are also thankful to you. Thank you so much.